even the other problem.
Please support Your Honor, Matthew Widener here on behalf of Ernie and Terry Hassel. We're the appellants in this case. We'd like to reserve 5 minutes to respond. This case comes on a final judgment of foreclosure that was entered in this case. The plaintiff at the trial court level originally filed a two-count foreclosure complaint. It's really important to note that in that initial complaint, they did not have a copy of the note that was attached or the note that was alleged to be at issue. They subsequently amended the complaint, and in that amended complaint, they included a copy of the note. What I assert is one of the biggest problems with this case is as we move to trial, when the witness for the dismissed plaintiff, if you will, or the original plaintiff, American Home Mortgage Servicing, got up on stand and began testifying to what is the key issue in this case, and that is standing at inception. As this court and other courts have noted, it's important to note when the original note was in possession and if it's got an endorsement on that, when that endorsement appeared on the note. And so as the dismissed plaintiff, American Home Mortgage Servicing representative, got up on stand and was testifying, the witness was saying, and Mr. Gachet presented a copy of the note and asked the witness, is this a copy of the note that was in your possession? And she said, over my objection, yes. I objected and did it repeatedly because the witness was referring to books and records, as she called them, my business records that I prepared in preparation for the deposition and in preparation for the trial. And she said, yes, that was the note that was in our possession based on those records. Again, I objected to that. And so that's a key issue here, because what this case is really about is standing in the inability or the failure of the plaintiff at the trial court level to prove their standing. So that's the key issue, and that's that evidentiary issue that occurred. The witnesses repeatedly testified based on business records that were never entered in. The second big point that I made repeatedly was that it was clear, and frankly it was undisputed, that when the plaintiff was in the courtroom, they were there in a representative capacity. They repeatedly referred to themselves as servicer, and while servicer is never appropriately defined at the trial court level, and in this complaint was not clearly defined, the plaintiff repeatedly referred to the term as servicer. In our brief, I pull out the definition of what servicer is, but what was crystallized at trial when the counsel for plaintiff stood up and said, we can't tell you who owns this note. Not we won't, or we can't meet our evidentiary burden. He said, we can't tell you who owns this note. And so...
Does that really make a difference?
Absolutely, Your Honor.
Isn't the law, we focus on who owns the original note at the inception of the lawsuit, and the policy is so that somebody else later on can't come on and say, well, no, I'm the person you should have paid. So as long as I have the original note, what's the problem with whether it's a loan servicer of an undisclosed principal?
Sure. The first part of that argument is it a negotiable instrument that would allow someone else to come in here? And as I noted as part 3 of my argument, it's not a negotiable instrument. And so even if they're coming into court with this document, which is payable to someone else, it clearly is important who the owner is.
It's endorsed in blank.
It is, Your Honor.
Right, okay.
It became endorsed in blank at some point in time, but again, looking back at Feltus and the other cases, when did it become endorsed in blank is the key question. Okay, so the question is, does it matter who owns and holds the note? Well, absolutely. In all of our cases, Dollar v. Detto is one that's cited. But that fundamental principle of law, that we have a right to confront our accusers, or in agency law, if an agent is coming into court...
Is there any dispute by your client that they haven't paid on the note?
There's not, Your Honor, but the question...
What do they want to confront them about?
Whenever the question comes...
There's a note in a mortgage that is recorded in public records. And now the real note and mortgage are in this court file, right? And there's no dispute your client signed those documents and haven't made payments on them, right? So where is the risk here that somehow this money is going to be used for something other than what the contracts between these parties call for?
My response to that question is that while a homeowner has an obligation to pay a debt, they also have the plaintiff also has an obligation to prove that they are legally entitled to collect that debt. And how can we have a legal system?
So if we reverse remand here, the originals are now in the possession of the court.
They are, Your Honor.
So we go back, the current plaintiff says, I have possession of them now I want this judgment. And they get the same judgment.
Here's the good news, Your Honor. Even if you reverse and remand and grant us judgment in our favor, which is what I'm requesting here, they get a do-over. They could just refile the case tomorrow. The problem with this case is, particularly that substitution of party plaintiff, done ex parte, and that's where this thing really got sideways.
They get a do-over.
Yes, sir.
We reach the same result.
Not necessarily, because again, well, they're going to have another trial. They're going to do it again, and they're going to have to do it correctly.
There's no question that they're in physical possession of the note mortgage now, because they put it into evidence in this file, right?
Well, the question is, they may be in custody of it. There is a note that is in a court file, but the question is...
Custody is not enough under Florida law?
Well, and this is really the question that I think falls on this court to answer about this negotiability analysis, because...
If it's a negotiable instrument, I guess I'm concerned the rule you're advocating just is really going to mess up how we deal with negotiable instruments, isn't it?
Here's a fantastic thing. There's this law review article that's cited in our brief. It's called by Professor Whitman. And it cites the proposition they reviewed every single case in which the issue of negotiability of a mortgage note had been reported on by a court, both federal and a state court. And incredibly, footnote 99 says he could only find 2 opinions in the entire country in which a court ever analyzed a mortgage promissory note. Now, I might add to that one other opinion. That's GMAC versus Honest Air by these great judges in the 2nd DCA. That's about the only case in this entire state in which an appellate court ever looked at negotiability and looked at a document and compared that document with the very simple definition of negotiability. And I think the instruction, and that court said, you have to engage in an analysis of negotiability. We cannot just assume that a document is negotiable, even if it says promissory note on it. Could a promissory note be negotiable? It might be, but we've got to look at the definition of negotiable instrument and determine whether the document that sits before us is a negotiable instrument.
Wait, I have a note payable to X. X endorses it in blank. Y is now the holder and the owner. Under Article 9, isn't that enough?
Well, again, we're dealing with Article 3.
I'm sorry, 3. I was talking to a student earlier about Article 9.
Well, Article 9, you're exactly right.
Yeah.
Article 9 is where this belongs. And I believe that's the way this was all set up and intended to be from the beginning, not Article 3. This, as you quoted in that opinion, is a courier that has all kinds of luggage. This thing is loaded down with luggage. And there is a reason for this on both sides, both the plaintiff and on the defendant side, as to why we want simplicity and finality. Your example of a check, that's what I use in court. I say, a check made out to Judge LaRose, but if it's endorsed in blank, I can run out and I can enforce it. This is not a check that's a simple agreement to pay a fixed sum of money. Let's just not even get off the first page, and let's deal with what's in big, bold letters there right on the front. What is it? It says a borrower's promised to pay money, $519,000. But the big, bold letters there on the front that I've highlighted here, they say, but it might not be $519,000. It may be up to $622,000. So that fails even before we get into all those other complex conditions or undertakings.
My understanding is all notes, virtually all notes, are worded that way. Your test suggests that I can never have a negotiable instrument.
I don't think so. Well, you may be right about if interest is adding on to it, you're correct. But what is explicitly stated in here is that the principal amount of the loan may change. And that's the big distinction here. And let's keep in mind one other thing. When this court writes an opinion, I hope, which determines that this note is not negotiable, that does not mean that every note isn't negotiable. It doesn't mean that every foreclosure case is going to get fouled up. It's going to say that based on the document that was presented before this court, this is not negotiable. I hope the opinion that comes out of this court says we must, trial court, engage in an analysis to determine whether, in fact, a document is negotiable. Because trial court should no sooner be looking at all notes and saying they're negotiable than trial courts in defense murder cases should say probable cause affidavits are valid or anything else. The bottom line is this. The two good cases...
Is the note negotiable if held by the principal?
Is the note negotiable? Well, we have to look at the note. A note may be negotiable if it's held by
your concerns, I understand. I have a servicing agent who's purporting to foreclose on this note and mortgage.
Right.
Is that the problem?
That's one problem.
Well, let me ask, if the principal, the undisclosed principal, brought the action in its own name, do I have a negotiability problem with the note?
Not if it's in their own name, because it's not a negotiable analysis, because it's made out to them, they're in court with it, it's not been negotiated, it's been issued, and so the issuer is now in court enforcing that document. But again, I think this court has a real opportunity to look at GMAC versus Honest Air, which is the only opinion I've found in this state which engages in any analysis. And that provides the framework for analysis. We look at the simple definition, a promise to pay a fixed sum of money with no conditions or undertaking other than the payment of that, and then direct the trial courts to engage in that analysis. We might also look at Holly Hill, which is also cited. And Holly Hill says, well, what happens when there's another document which is part of this transaction? And as in most cases, there is a mortgage that is attached to that. So that's another part. Sims versus New Falls is that other case.
Tell me how the mortgage fits into this. The mortgage is just an incident of ownership of the note.
Well, as the court in Holly Hill said, if it just references, then perhaps it doesn't come in, and that doesn't foul up negotiability, as Professor Whitman articulated. But when the mortgage becomes integrated into the document, then clearly it becomes non-negotiable. And where is the evidence of integration? Well, let's start first with the Sims versus New Falls case. That Sims versus New Falls case clearly articulated that in that case, the Fannie Mae, when they drafted this, they intended them to be integrated documents. And then let's look at the specific document that's at issue in this case. Again, that's what we have to do. We have to look at the note. We have to look at the mortgage and go through it and say, well, wait a minute. Are there things within the mortgage that are referenced that render it non-negotiable? The point with this...
But if this is a Fannie Mae transaction, then there are millions, perhaps hundreds of millions of these transactions whose negotiability is now questionable under your theory. Is that fair?
Yes, Your Honor. Let me make this point. This second DCA has an opportunity to say trial courts engage in an analysis. I don't know about all those other cases, and it's not before the court right now. But I think this second DCA, who's had a long history of good, hard opinions, can issue an opinion to the trial court which says you have to engage in a negotiability analysis. We can't just assume that it's negotiable. We have an obligation to look at these documents and find out whether they're negotiable or not. You know, one of my favorite opinions, Mers versus Aziz. This court said that we were reversing because the trial court, Judge Logan, said Mers could never be the plaintiff in these cases. We should have gone back and we should have started with that analysis in footnote 2, which says if you challenged how Mers got to be the owner and holder, maybe then you could be the plaintiff in those cases. But the point about the mortgage...
But if I use Mers, and there's a comparable case out of the fourth DCA, I think, I mean, the thrust of your argument today deals on the negotiability, because there seems to be no question but that a servicing agent could bring the foreclosure action.
That's a good point. Could. How could they? If they came to court with some evidence of their agency relationship.
Why do I need, well, I guess I keep coming back, why do I need agency, proof of agency, if I'm holding the original note?
Well, again, that's Dollar versus Ghetto. And so let's say you are holding the original note, but there is this undisclosed principle about crime. Dollar said there's no proof, and in fact they adduced at the oral arguments that there was no consent from the principal. And think about this. I'm standing in court and I'm saying that I've been saying for 2 years, who's the principal here? Who's authorized this action? And the attorney stands up and says, we can't prove that. Well, how could you prove that you have agency responsibility?
Well, I guess I go back to Judge Altenburn's point. If we were to write and we reversed and allowed your clients a do-over, your desire would be for the principal to be brought in.
I think it's clear, the case law is clear, that if you're acting in a representative capacity, you have to look at the comment to Rule 1.210 regarding capacity and parties. It says if a party's acting in a representative capacity, they should name...
So either the principal is brought in as a named plaintiff or there's some evidence of the relationship.
Correct.
As a practical matter, I still think we come to the same result.
Not necessarily. Let's look at Elston versus CW Capital on the 4th, where Elston said, and they said this is a servicer case, and it's important, it's necessary that the servicer be joined to ratify the plaintiff's actions. My good colleague in the brief attempted to distinguish that case and said to this court, but that shouldn't be applied here because that's a servicer case. Well, we don't know if this is or is not a servicer case. All we know is there's an owner somewhere behind the scenes that they refuse to disclose. In all of our case law regarding agents...
If I'm the servicing agent and I hold the actual original note and it's in the court file, if foreclosure and judgment is entered against your client, the undisclosed principal cannot come back in the future and say, as to your clients, you should have paid me. There may be a problem as between principal and agent, but I'm having difficulty understanding the problem between undisclosed principal and your client.
So we frequently hear this statement that a thief can enforce a note. Well, that's not true if there's evidence in court we adduce that they're a thief. But what if the principal really comes forward and says, wait a minute, this servicer didn't have any authority to do this, like in Dollar versus Detto? What if it's adduced that, in fact, the real owner didn't authorize this?
That's why we have the protection of requiring the original note. The problem may be between the principal and its agent that exceeded its authority.
Sure. So, but we have these affidavits of lost note that are filed and that sort of thing, and you may say, well, that would get us around this business of original note. Remember, we got courts that are returning original notes back to plaintiffs. Johnson versus Hublett is a case that articulated where that's an improper practice. But the fact of the matter is, substantively, even if Your Honor is correct, do we want this permissible? Do we just want to assume that agents have the authority to act on behalf of their principal without any proof, especially when challenged? I would submit to the court that it's important as a matter of pleading that be pled up, and there's some rules that seem to assert that if you're acting in a representative capacity, you have to show that you have the authority to do so. Think about it.
You're into your rebuttal time at this point in time, but before you sit down, I want to make sure, I'm making an assumption, I want to make sure it's a fair assumption that if the note had been formally assigned, we would not have the negotiability issues. The negotiability issues are because it's a blank endorsement?
That would be a second issue, but the question becomes who is it assigned from? I would submit to you that under Article 9, it's assigned from whoever owns it at that point in time.
It's not assigned. I'm just
correct, Your Honor.
Saying that your argument is because it's endorsed in blank as compared to having a formal assignment here.
Correct, Your Honor. In Article 9, that's the way it transfers, because that's a whole bundle of sticks. The mortgage note, everything. Okay. Thank you, Your Honor.
Ms. Hopkins?
May it please the Court, Kim Hopkins for the Appellate. As counsel stated, this case is before Your Honors after going to trial, a bench trial. We proved the elements of a standard mortgage foreclosure case. We proved we had standing, that we met all conditions precedent, that there was a default, and the amounts that were due and owing. On that basis, the trial court granted judgment in our favor. A number of the issues that have been brought before this court today were not preserved in the lower court, but I think that the key question that we would even possibly urge this court to address is whether or not it is important who owns the note. In this case, we were the servicer. OMSI was the initial plaintiff, and they pled in their complaint that they were the holder of the note. All throughout, that was the evidence that was presented to the court. We would suggest that the law requires nothing more.
I thought most of the pleadings I see, they all say, I hold and own.
They do say that sometimes, and if that's the case, then I'm sure that that's a perfectly well-pled allegation.
And when I don't hold, there may be some questions about I own it, but I don't hold it because it's a lost note or something like that.
Correct. And then I've seen other ones where they want Fannie Mae owns and someone else holds. But what's required in order to bring a foreclosure action is that you hold the note, and that is what we did. We possessed the note. We presented it to the trial court. It's currently still in the file. OMSI presented that when they were still the plaintiff before the other servicer was the current plaintiff was even substituted.
So if the original servicer, suppose the original servicer did not have the authority to maintain a foreclosure action and then transfers the note to you, are you in a you're still the holder? Are you in a better position because?
Well, I think that goes to what your earlier questions were. I think that there's a problem with authority, that the question becomes between the owner and the holder, and it's separate action involving whether or not agency.
And the mortgagor would be absolved of any obligation in that situation as between the principal and the servicing agent?
No. I think that you would still be able to go forward if you're a real party in interest with the foreclosure action and proceed and win. And if there was a problem with the principal suggesting later at some point in time that they didn't have the authority to do so, then that's resolved in a separate...
Under no circumstances, under this hypo, would the principal be able to come back against a mortgagor?
No. No.
Okay.
I think if you have a valid holder of the note proceeds in a foreclosure action and wins against the borrower, that stands. If there is some other problem outside the parameters of that foreclosure action, then like you're saying, there would be an action between the principal and the agent. I don't think that they could come separately against them any more than anybody else could. So
what is the proof here that the party filing this foreclosure action had possession of the note on the day they filed it?
From the testimony of the OMSI representative, she testified based upon her review of the note as well as the review of her business records that they held the note on July 1st, 2008, and that was months before the complaint was filed.
Was this using the standard questions to introduce business records, or is this her personal knowledge? I don't quite understand what the evidence is here.
Okay. They did raise some objections to some of the beginning parts of her testimony concerning whether or not she was going to introduce the business records. But when we get to the actual questions that were asked of her, did OMSI hold the note prior to filing the complaint? And she said yes, there was no objection. So we would suggest that's not preserved. She later talked about the Bailey letter that was sent to counsel before the complaint was filed, and no objection was raised other than foundation at that time. So again, we would suggest that's not preserved. To the extent that this court disagrees with whether or not those issues were preserved, the record contains an affidavit that was filed in 2009, I believe, which attaches a copy of a screenshot showing the acquisition date of the note from OMSI, for OMSI. So whether or not there were hearsay objections that were rightly made and preserved at trial court, the record contains evidence that OMSI held the note prior to the filing of the lawsuit, and so any error would be harmless. I don't know how much this court wants to talk about the negotiability of the note issue. We would suggest that that wasn't properly preserved either. There was some issue raised in an affirmative defense that said any note that could be provided would not be negotiable. In court, counsel stated something along the lines of there's a whole bunch of instructions in this note and that's it. In the appeal for the first time to this court, now we have a laundry list of reasons why supposedly the note is not negotiable.
Let's take one in a hypothetical situation. Mr. Widener is saying, for example, the note doesn't provide for a debt certain.
Right, but we've provided the court with all cases that go through each of the factors that supposedly make it non-negotiable, and courts have held that you can have a variable interest rate, that you can have additional fees.
But those are fees and changes in interest rates. I think Mr. Widener was speaking about terms of really you're going to be increasing the amount of the outstanding principal.
Well, I don't believe that that's the way it was presented in the appeal, and with all due respect. I think that he talks about the fact that there's a variable interest rate and that you have to look outside the note to figure out what that interest rate is, that somehow that creates a reason that this is not negotiable. We would suggest if there's case law that says that you're allowed to have a variable interest rate in a negotiable instrument, you have to look somewhere to choose that. You wouldn't pick it out of thin air, so that would impact the negotiability.
And a note would typically tell you what index you're going to look at?
I'm sorry, what?
The note would tell you what index you're going to look at?
Correct.
Okay.
And to the extent that they make the argument to this court about whether or not the note includes by reference the terms of the mortgage, that was never made below. That argument was never made in any way, shape, or form below. And we would further suggest looking at the actual note shows that, according to the Holly Hills opinion, that it was just a mere reference to the mortgage and that it would be acceptable even if that was preserved in a lower court. Again, with respect to the ownership of the note, there are a lot of cases out there that talk about own and hold, but in this situation we have a plaintiff who pled only that they held the note. They proved to this court that they held an original note endorsed in blank with testimony and record evidence that they owned it prior to the filing of the lawsuit. I think that what he's asking in terms of looking for a broader requirement for what possess the note means, I think is not supported by the case law.
Well, if somebody is just a servicing agent, I don't know what that means. I suppose it could be a very narrow agency, it could be a very broad agency. Mm-hmm. Shouldn't there be some requirement for a servicing agent, in addition to holding the note, has to be authorized to be able to proceed with the foreclosure?
No, Your Honor, I don't
We
think
don't
so.
need to know the scope of its agency relationship. I suppose I don't care who the principal is, but shouldn't I need to know that within the scope of this agency, the servicing agent can proceed in the foreclosure?
I think that would only be a requirement if you have it pled in such a way as it was in the Elston case, where the plaintiff comes before the court claiming to be a servicer acting on behalf of someone else, and all of their pleadings, their allegations make that a relevant inquiry. We don't have that in this case. We have the plaintiff coming forward, pleading that they are the holder of the note, and establishing that. Now,
but I thought they pled that they were a servicing agent.
It doesn't say that in the complaint. I was looking at that during counsel's argument. It says plaintiff at paragraph 8. Well, it doesn't say it's a servicer. In paragraph 7, it says prior to the filing of this action, plaintiff acquired the right to enforce the note and mortgage from the party entitled to enforce the note and mortgage.
Who was a servicer?
But it doesn't say that it...
But we know from the record it was a servicer.
Well, we know that the subsequent plaintiff that was substituted,
right,
RCS, obtained it from OMSI. But at the time
that
this was filed, we're still going, this is OMSI still.
I understand, but we don't know the scope of its agency.
Right. But I would suggest that's not necessary. If you go to paragraph 8, then what we plead and what we prove to the court is that we hold the note and the mortgage. And so nothing more is required, and I think that it gets thrown in almost as a term of art, owner and holder. It's in every opinion over and over again, and I don't think that that's actually what the law requires, and we would invite the court to address that if they think that that's important, because what the law really requires is that you prove that you hold the original document, and that is and it's in your possession, and we did that without question. There is no evidence to contradict that in the record, and on that basis we'd ask the court to affirm.
Please, the court, I'll be quick. I'll lead off with exactly what she just ended with. The primary problem here is there isn't good evidence that they owned and hold. Look at the testimony beginning at 37 where the witness is up there and they're testifying these business records. I'm objecting. The court is overruling my objection, but you're testifying about that's how we own and hold. That objection is preserved for the record. We pay careful attention to paragraph 8. They say they hold or they own or they have the right to enforce. Those could be contradictory terms, not just that they hold. That's a key point. It's a question about whether they are the real party in interest, and clearly whether they have the agency authority. They're standing in court saying, we can't tell you who owns this. That means they can't tell you who gave them the agency authority, if at all, if anything, with regard to the argument regarding non-negotiability and whether or not that was preserved. Look at paragraph 4E of the note, which is specifically referenced in our note. That's where it talks about negatively amortizing and how it comes up there.
How did you preserve it? Did you move to dismiss this proceeding because it was on a non-negotiable note, or what was your procedure to preserve it?
In the middle of the court, I stood up and said, Your Honor, we have to go through the negotiability analysis. The court said, I'll hear argument on negotiability analysis. We stood up there. I started to go through it. I said, there's conditions. Let's go through it. The court, and it's not reflected in the transcript, the court said, I'll take this, and then went out for lunch, came back in and said, I looked at Riggs, it's negotiable. The point I want to make about Riggs and any of these other cases that talk about a mortgage note being negotiable, zero analysis. Not a single opinion has looked at a note and provided a framework for analysis. I invite the court to do so. One other key point, and that is 673.2031. This has to do with negotiation. If a transferor purports to transfer less than the full document, negotiation has not occurred. That's another important part of this analysis regarding holder and whether it's a negotiable instrument. If all they have is the servicing rights, that gets back to Judge Rose and your point about we have to analyze the agency relationship. But there's not a single opinion out here that tells us what does that mean. If a transferor purports to transfer less than the entire instrument, negotiation has not occurred. They can't be a holder under those circumstances.
How
Thank you, Your Honor.
Thank you. Last case today is Robin Cummings, successor trustee versus William Belcher.